Hello, my name is Benjamin Hart. I'm an American tax attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video today we're going to be discussing very briefly, just kind of providing an overview with respect to double tax treaties here in Thailand. The following is taken from the Department of Revenue, the Revenue Department in Thailand's website. I'm just going to quote a few things from that site. Scope of double tax agreements generally. Persons covered. The DTA, double tax agreement, applies to persons who are residents of the contracting states. Double tax treaties are essentially, in a sense, they're kind of like business contracts between two governments with respect to the taxation of the citizenry and the incorporated entities existing therein. And basically what they're designed to do is, in a way, mitigate tax liability for entities or individuals who are undertaking business or earning income in both jurisdictions or one jurisdiction, but actually that individual or entity originated in the other jurisdiction. It's there to both mitigate certain tax liabilities and, in a way, I think it incentivizes business activity, investment activity, employment activity, income generation, revenue generation in both jurisdictions oftentimes because it incentivizes an individual. If they're going to be taxed 2 times on their endeavors in a foreign country, it can be problematic. It can basically lead to that individual being apathetic as to wanting to generate any revenue, because what's the point? I can't earn enough or generate enough that it's worthwhile. Again, this is very broad and general as far as the video on this topic goes. Persons covered. The DTA applies to persons who are residents of the contracting states. In order to be classified as a Thai resident and be entitled to treaty benefits, a person must be one of the following. First, an individual who stays in Thailand for a period or periods exceeding in the aggregate 180 days in a tax year, or a juristic person who is incorporated under the Civil and Commercial Code of Thailand. Types of taxes covered. Taxes covered. Part 2. The DTA applies to only income taxes, namely personal income tax, corporate income tax, and petroleum income tax. Other indirect taxes, such as value-added tax and specific business tax, are not covered by the DTA. In general, the DTA does not stipulate any specific item of income and tax rate. This is important. Different countries have different tax rates. For example, the United States and Thailand are going to have a qualitatively different agreement than, say, the agreement between Hong Kong and Thailand, or the agreement between Korea and Thailand, or the agreement between Belgium and Thailand. It's just going to differ countrywide. The focus of quoting further, the focus of a DTA is the elimination of double taxation. Each DTA may prescribe different methods of elimination of double taxation of a person by the resident country. I want to go through that again, just to reiterate. Each double tax agreement, each double tax treaty may prescribe different methods of elimination of double taxation of a person by the resident country. Again, things are going to be highly circumstantially different. The analysis, how you're going to progress, the practical aspects of one's operations when looking or trying to make one's efforts comport with provisions of a double tax agreement are going to be very different depending on the jurisdictions involved. It should further be noted the tax credit is not absolute. It can only be used against taxes which would be owing in the home country from the specific income which was earned by the person involved, by that entity. Okay, so it's for taxes in the home country. For example, Americans are subject to tax on our worldwide income, but pursuant to certain provisions of the double tax treaty with Thailand, that taxing authority may be, well, I shouldn't say that tax liability may be somewhat mitigated under the provisions of the treaty itself. I just kind of wanted to go through the list. Again, this is all from the Revenue Department's website, but I wanted to go ahead and list, and by the way, the Thai Revenue Department's website can be found at rd.go.th, rd.go.th. But the countries that have double tax treaties with Thailand, or double tax agreements: Armenia, Australia, Austria, Bahrain, Bangladesh, Belarus, Belgium, Bulgaria, Canada, Chile, People's Republic of China, Cyprus, Czech Republic, Denmark, Estonia, Finland, France, Germany, Great Britain and Northern Ireland, Hong Kong, Hungary, India, Indonesia, Ireland, Israel, Italy, Japan, Korea, Kuwait, Laos, Luxembourg, Malaysia, Mauritius, Myanmar, Nepal, Netherlands, New Zealand, Norway, Oman, Pakistan, Philippines, Poland, Romania, Russia, Seychelles, Singapore, Slovenia, South Africa, Spain, Sri Lanka, Sweden, Switzerland, Taiwan, Tajikistan, Turkey, Ukraine, United Arab Emirates, United States of America, Uzbekistan, and Vietnam. So quite a wide list, quite a long list of countries that are covered by double tax agreements here in the kingdom. As I noted previously, the provisions of each of those agreements, while substantially similar in certain cases, are going to have specific legal changes, legal differences, formulaic differences, just provisional differences between the agreements between those specific countries and Thailand regarding double taxation matters. So it's very, very prudent to retain the advice and the assistance of competent professional counsel with respect to tax matters on these issues, as it's going to be, again, circumstantially dependent based on the specific circumstances in the given case.